Good morning, everyone, and welcome. This is a big day for the Delaware Supreme Court. We are now back to full strength, and I am pleased to welcome our newest justices to their first en banc argument. So with that, let's proceed with introductions.
May it please the court, and it is an honor to appear before this court today in full strength. Bar Flynn from Young, Conaway, Stargate, and Taylor. For appellees, Howard Lutnick, CF Group Management, Inc., Cantor Fitzgerald, LP. With me at council table is Eric Leon from Latham & Watkins. Good morning, Your Honor. Mr. Leon, I also should introduce, not at council table, our client representative, David Paul, who's Assistant General Counsel of Cantor. Mr. Leon will be presenting argument for our clients today. With the court's permission, the defendants would like to divide the arguments between Mr. Leon, who would address process and price, and Ms. Zaharsky, who will address issues of director independence.
Thank you, Mr. Flynn, and welcome, everyone. Mr. DiCamillo.
Good morning, Your Honors. Raymond DiCamillo from Richards, Layton & Finger on behalf of Linda Bell, Stephen Kerwood, and William Moran. Here with me at council table from Mayor Brown is Nicole Zaharsky, who has been admitted pro hoc and will present argument on behalf of our clients.
Thank you very much and welcome. Mr. Varallo.
If I may, Your Honor, I'll begin with introductions. It's my pleasure today to appear before the court, Greg Varela from Bernstein Litowitz for the appellants. I have with me at a council table my partner, Jeroen van Kwavegen, my colleague, Andrew Blumberg, co-counsel from Grant and Eisenhower, Christine McIntosh, and in the seats, co-counsel CJ Arico, who was my partner and who will be joining Grant and Eisenhower in just a few days, and co-counsel as well, Vivek Gupta.
Welcome, everyone.
May it please the court. The lower court made three fundamental errors that absolutely mandate reversal of its decision. Each stemmed from the court's misapplication of entire fairness law as set forth in this tribunal. First, taking all but one of the lower court's factual findings concerning process, proper application of controlling precedent should have mandated a finding of unfairness. Having found that during the process, the controller stood on both sides of the deal and was incented to cause BGC to overpay, the controller's direct involvement, quote, marred, close quote, the process. The lead director was negligent and, quote, perhaps grossly so. The lead director actively withheld material information from the committee and, quote, must have known better, close quote. It was error to conclude that the process was entirely fair. Second, the lower court misapplied this court's holding in Weinberger versus UOP to excuse the decision to hide material valuation information from the special committee, which showed that not even the controller's asking price was close to fair. Third, the lower court misapplied Weinberger to find that the defendants showed the most scrupulous inherent fairness of the bargain, having found that plaintiffs proved a price that was $70 million below the transaction price without accounting for the $89.2 million in additional distributions. The court nonetheless found that price was entirely fair based solely on an illustrative example, an illustrative comparable companies analysis that was not grounded in accepted financial principles and contrary to relevant market evidence. Indeed, members of the court, the result itself compels reversal. This is the first time in our history where a controller won an entire fairness case while defending a transaction in which the controller's price went up by hundreds of millions of dollars. As the Court of Chancery colorfully said in the America's Mining decision, the special committee had their hands on the oars, but the boat went backwards.
So, Mr. Varela, just as an initial matter, tell me why you're not arguing against factual findings made after trial.
So, Your Honor, the factual findings, let's talk about process, for example. The factual findings here are findings that my client embraces. Findings, for example, that the involvement of Mr. Lutnick and Mr. Moran together, not shared with the other members of the committee, marred the process. That Mr. Moran...
So I know you like those, but what about the other stuff?
Well, Your Honor, the other stuff were conclusions drawn from a misapplication of the law, and I can deal with any of those conclusions Your Honor would like me to deal with.
Spend a couple minutes to tell me how the law was misapplied.
Well, Your Honor, we start with process. So in the process law in our jurisprudence contemplates a special committee which was attempting at its best to simulate arm's-length bargaining, adversarial arm's-length bargaining. And so we're looking at this from the perspective of what would you expect arm's-length adversaries to do? And when you think about that as the correct lens to apply for this particular case, you have great trouble applying that lens and coming to the conclusion the lower court did in a circumstance where you gave your adversary not only an opportunity to pick your advisors, but you gave your adversary an opportunity to shape the scope of those advisors' work. Let's think about the banker here, for example. Sandler O'Neill was the chosen banker. It was one of two bankers selected by the controller, Mr. Lutnick, and suggested by the controller, Mr. Lutnick. Mr. Lutnick and Mr. Moran, the committee member, then jointly interviewed the two bankers. Sandler O'Neill was chosen. What happened next? Sandler O'Neill sent in a proposed form of retention letter. That form contemplated that they would be negotiating the price of the transaction. What did Mr. Moran do? He sent on that retention letter to Mr. Lutnick directly, and he asked, do we want them to negotiate price? Mr. Lutnick responded, yes. So let's just step back and think about what arm's-length adversaries would do. Would an arm's-length adversary give a veto over the scope of his or its advisor's work to your negotiation adversary? That makes no sense at all, Your Honor. That just doesn't happen in an arm's-length transaction. And then let's look at the lawyer. So Debevoise was chosen as the lawyer here. What did Mr. Moran say about Debevoise? Well, first of all, he gave Mr. Lutnick the opportunity to veto the choice of Debevoise. And when asked at trial, what would you have done if the controller had vetoed your counsel? He said quite candidly and frankly, we would have found another lawyer. This is not the stuff of arm's length transactions and real adversarial negotiations. And then let's step forward and think about price, for example.
Before you go on to price, I want to stop. What you've raised so far goes to the independence of the committee. Would you agree that the fair dealing component of entire fairness looks beyond the committee itself? There are other factors involved.
Of course, Your Honor, I would.
And do you have any problem with the analysis for instance, timing of the transaction, structure of the transaction, the traditional fair dealing components?
I'm glad you asked me about timing, Your Honor. Let's talk about that for a moment. Well, what do we know about timing? Well, we know that there was a long lead-up period where the committee tried to get diligence information, and then we know that at the end of the transaction, the controller decided that it was important to move forward with alacrity. So what happened? We know that over the Memorial Day holiday, both the banker and Mr. Moran were interrupted during their holiday. Mr. Lutnick called them both and said, we really need to get this moving. 6 days later, on June 6th, was the one and only price negotiation. Now, leading up to that price negotiation, one of the things that the special committee realized it needed, was information regarding the earlier CCRE buyout and the pricing information drawn from that buyout. Just to make sure we're all on the same page on this, immediately prior to proposing this deal, Mr. Lutnick had engaged with the private investors who had bought CCRE with him and convinced them to sell their interests so that he could then go forward with this transaction. That was arm's length adversarial negotiation, and it set a market price, albeit in private dealings, but at arm's length between sophisticated investors who held those CCR interests and Mr. Lutnick. So by the time we're talking about this June 6 price negotiation, what you had was the committee realizing that that most recent CCR buyout was an important one and trying to get the information. Now, when they get to the June 6 price negotiation, they thought, Sandler and Neal thought it had the information it needed from that CCRE buyout data. But what we know, the lower court said in this particular instance, if the committee had not gotten full information, that might evidence a lack of fair dealing. That was page 66 and 67 of the lower court's opinion. But the lower court ignored that Sandler was, quote, not yet sure of dates and details for, quote, other minority interests in its presentation to the committee right before the negotiation. And the court also ignored that Mr. Edelman, who was a partner at Cantor, one of the two controllers, the entity through which Mr. Lutnick controlled this company, emailed Mr. Lutnick the day after Sandler presented to the committee saying that Sandler could not, quote, really piece together the pricing precisely from what they had received. And you'll find that at A1382.
What were they missing? I have struggled to determine from the briefs and the record what they were missing. I say that because I also understand that Mr. Sterling testified when asked point blank whether he received all the diligence materials he requested, that he got them.
Well, Your Honor, what they got, what Sandler did was use the wrong numbers and got the analysis wrong. So they didn't have the up-to-date information on the CCRE buyouts. What they did was they used the CCRE book value after CCRE had partially funded the buyouts. And that makes the premium in the CCRE deal look higher and with the lower book value. And so they didn't have the full information. They made an obvious mistake, a mistake that was generated by the controller saying, we need to get this done now, we need to get to it right away. And so there was the interposition of the controller's will to shape the timing of the final negotiation. Now let me tell you another thing about that final negotiation, Your Honor. It's a very strange record here. We know that it happened on one day. It happened on June 6th of 2017. We know that that's the time price was negotiated. But that is all we know about that negotiation, and it's all we know about the negotiation because none of the participants, the individual participants in the negotiation who testified, were able to remember anything about the bid and ask. In fact, the lower court at page 2 of the opinion refers to this as a, quote, mystery, close quote. And indeed it was a mystery, and it was a mystery of the defendant's making. Why do I say that? Not only because their clients couldn't remember what happened, what the back and forth was, what any of the negotiation history was, but my friends on the other side made a tactical decision at trial not to call and put on evidence from the advisors. One would have thought that if they had a negotiation history that they were proud of and their clients had forgotten it, they would have called the advisors to the stand and said exactly what happened, who made what offer, who made what counteroffer, how did this evolve. Instead, we have a, quote, mystery in the record. And this is in the context of the defendants having the burden throughout. Why do I say that? We know that under America's Mining, which the court made a prospective holding, that if you're not able to shift the burden prior to trial, the defendants bear the burden of intrinsic fairness for the entire trial period, full stop. There's no longer any shift at trial. And so knowing that they had the burden, knowing that that was a burden that was going to sit with them for the entirety of the trial, there's this hole in the record, and it's a hole in the record that my friends caused by not filling it in.
Mr. Varela, I'm sorry to interrupt you, but I want to get this in before time runs. I have a question about the Walker Dunlop fair value analysis that the court did. This court in Rosenblatt said the valuation methodology can depend on the facts and circumstances of the case. And only one comparator was used. And as I understand it, your expert agreed that Walker Dunlop was the most relevant comparable. So why was the court wrong to conclude that this was a circumstance where relying on one comparable company that everybody agreed was comparable was appropriate?
I'm glad you asked that question, Your Honor. Let me answer it directly. The court wasn't wrong by relying on one comparable because, as the record shows, everyone did agree that was the most comparable company. What the court did, and the error that we complain about with respect to fair price, is directly related to how the court used that data. What the court did was it took the one comparable data and it took Berkeley Point and directly applied the multiples from the comparable company. There was no analysis whatsoever. You can find this in one paragraph on page 89. In fact, it's the top paragraph on page 89 of the court's opinion. One paragraph where the court simply takes these multiples and applies them. To do a comparable company's analysis, you have to begin by recognizing that the companies you're comparing to the company you're trying to value are different. In fact, in the several pages leading up to that one paragraph on page 89, the Vice Chancellor below explains how Walker and Dunlop was, in fact, different than Berkeley Point. It's by nature, it's true. There's no such thing as identical twins in the corporate world, right? You've got companies that are different. And to do a comparable companies analysis that makes sense, that is consistent with recognized methodology in the financial world, you need to adjust those multiples so that you make up for the differences between the comparator company and the company you're trying to value. That is the error the lower court made. Her Honor simply took the numbers without any adjustment whatsoever, applied them and said, aha, that's the price.
What's our standard of review on that one?
Your standard review with respect to expert work, Your Honor, to the extent you're leaning on facts in that expert work, of course, the court is deferential. But in a circumstance where the question is, did the court correctly apply well-accepted financial methodology, the standard review is just that. Did the court correctly apply methodology? That's from the Dell Magnetar decision, Your Honor, where the court talked about the importance of applying that financial methodology in a sound way. And Your Honor, you can search as much as you want. You will find no treatise, no financial literature, and no Delaware authority which says it's okay simply to take the numbers from the one company and apply them to the other without doing an analysis and coming to a conclusion as to how to adjust those numbers. The court simply skipped that step. And the reason for that, Your Honor, is the court was relying on what the expert who was, by the way, found not to be reliable for all other purposes, the expert called an illustrative analysis. The expert didn't go in and form an opinion and offer this as an opinion. This was an illustrative analysis in the expert's presentation, and the court grabbed on it and said, yes, that makes sense and that works. That's not how it works. It's not consistent with the ordinary understanding of financial methodology, and it is error.
Your friends say that if the adjustment would have been made, it might have very likely, if I understand them correctly, moved the multiple in a direction you would not like. Is that something we can consider?
No, Your Honor, because it's not in the record. What you have, there is some language in the record with respect to the differences between the comparator company and our company. Let's see if I can find that readily for Your Honor. At pages 87 and 88 of the opinion, the court below noted that Walker and Dunlop had a broader product mix, that Walker and Dunlop had a successful debt brokerage, which our company didn't have, and was less reliant on so-called GSE loans. And in fact, that there was more income from origination fees at Walker and Dunlop. Those are things which suggest, and those are findings from the court at page 87 and 88 of the opinion, Those are all things which suggest Walker & Dunlop was a better company, a bigger company, a more established company, a more diversified company. If you do ordinary financial methodology and you think about Walker & Dunlop's multiples and our company's multiples, you would be adjusting Walker & Dunlop downward to get a fair number because of all those things I just said. Now, my friends can make up anything they want today, but the record, as found by the lower court, is what I've just indicated to you. There's nothing in the lower court's opinion suggesting or finding as a fact that Berkeley Point was, in fact, a stronger company than Walker & Dunlop, indeed just the opposite.
Mr. Varela, did your client argue to the court below that adjustments should be made to the comparable?
Yes, Your Honor. We most well. Let me back up. First of all, this was an illustrative analysis. This wasn't an opinion. Professor Hubbard was asked in cross-examination, "Why didn't you make changes?" And he said, and I think this is a direct quote, "I didn't want to." So this was a matter that was put forward before the court below. It was argued in the briefs below, and there were no changes made. Your Honors, you've covered in your questions a great deal of my argument. Let me make one other point, if I can, and then sit down unless you have other questions and save what time I can for rebuttal. I guess I'll make two other points. One is independence. Obviously, an independent committee is of great significance when we're talking about entire fairness and a controlled deal. In fact, there are cases suggesting that in a controlled deal, the court looks with even greater scrutiny at the independence of the directors.
And well, this is a little different, though, Mr. Varela. I mean, you know, a lot of these independence questions are decided on a motion.
That's correct, Your Honor, there.
You know, this is essentially after trial, after sitting in front of the judge, looking at the person in the eye. Isn't that a pretty important distinction here?
It is an important distinction, Your Honor, and there are distinctions in the cases, and I agree with Your Honor, but let me address that very specifically, and I think I can best do that with Mr. Curwood. Mr. Curwood was one of the members of the committee who testified at trial. The lower court made a finding about Mr. Curwood, and I'm quoting directly from page 57, the lower court's finding, and I quote, "The personal importance of his directorship could have colored his thinking had he been faced with a demand to accuse Lutnick of wrongdoing and pursue litigation against Lutnick," close quote. That's a direct finding, direct quote from the court's opinion. Mr. Curwood was a director who the lower court found, it's a finding, was incapable of impartially considering a demand because he relied on his directorship to support his family and pursue his career in public broadcasting. The court noted that approximately 63% of his income came from his directorship. Let me say that again. 63% of his income came from his directorship. The court wrote, and I quote, that it would be, quote, "difficult to imagine," close quote, "more personally motivating factors than, quote, supporting one's family and pursuing one's passions." That's page 44 of the opinion. But the lower court fell into error by attempting to segregate this finding, which it strangely reached by putting plaintiffs to proof at trial of the pleading standard of Rule 23.1, which to my knowledge has never been done in a trial before, segregate that finding from a finding that notwithstanding that Curwood relied on his directorship to support his family and pursue his passion in public broadcasting, he was nonetheless independent as a special committee member. Even though aggressive negotiation and simulating arm's length bargaining with the controller would have directly put his directorship at risk. The lower court's conclusion that Curwood's directorship could have mattered to him for one purpose but not another, with all due respect, at least to my mind, creates an insurmountable cognitive dissonance and doesn't correctly apply our law. Let me just briefly address Mr.
Are you saying that a director could never be lack independence for demand futility purposes but remain independent for other purposes?
Not at all, Your Honor. I'm saying quite the opposite. It's quite possible to lack independence for demand futility purposes and then prove independence at trial. The problem here is the fulcrum on which you make the judgment about demand futility. put aside that we were required to prove this at trial, and we did prove it at a trial, as opposed to merely allege it in connection with a 12b6 23.1 motion. The fulcrum for that finding was that 63% of his income came from this particular directorship, and it was critical to support his family and to pursue his career. In fact, the director involved, Mr. Kerwood, made a list of blessings. He did a spiritual exercise and came up with a list of 10 blessings in his life. One of them was his wife. And another one on that same list was the opportunity to be a director in Mr. Lutnick's companies. It was a spiritual
You're
blessing.
into your rebuttal pretty deep, so you might want to save a little time.
Your Honor, let me sum up. I don't want to sit down without saying, first of all, we rely on our brief for anything I didn't address today. But I also just want to spend a minute talking about the policy that we're talking about today. I spent more than 3 decades advising controllers, boards, and others in conflict transactions. I can say with certainty that one consequence of allowing this decision to stand will be to undermine the ability of counsel to persuade their clients, particularly independent board members, to demonstrate the fortitude necessary to actually negotiate in a way that this court's decisions require. An affirmance here radically weakens review of conflict transactions, and in turn, it necessarily weakens incentives for controllers to behave themselves in such transactions. This ruling transmutes entire fairness into something closer to business judgment than what this court contemplates for entire fairness, where an objective lack of independence is overcome by self-serving testimony, hiding material expert advice from the committee is excused by crediting testimony about the relative value of the evidence from the person who concealed it in the first place, and failure of proof on fair price is excused based solely on an illustrative analysis. Your Honors, entire fairness law has gone off the rails, and it's time to put it back. This is the place to start, and I appreciate very much your time.
Thank you very much.
May it please the court, thank you for the opportunity to be heard today. Appellants are asking this court to pretend that the trial in this case never happened. They raised the exact same factual issues before this court that they raised in the trial court. The whole purpose of the trial was to resolve those factual issues. Over the 5-day trial, the Vice Chancellor heard testimony from 13 different witnesses, including all the key players in the deal. The parties collectively submitted over 1,200 exhibits. And the court did not just rely on the lawyers to do the cross-examining and ask the questions. For virtually every witness, the Vice Chancellor asked its own questions of the witnesses and pressed those witnesses until the court got the information that it wanted. After that, the Vice Chancellor did exactly as this court instructed in Cinerama. It evaluated the credibility of the witnesses, balanced the evidence, it made specific and detailed factual findings as to both process and price, and then it made a unitary determination that the transaction was entirely fair to the BGC shareholders. On appeal, appellants just want a do-over. Respectfully, they do not get one. The trial happened. The court's findings are now entitled to substantial deference. Your Honor asked, how was the law misapplied? The short answer, it was not. The trial court applied the exact right legal framework here. Appellants just disagree with the court's credibility determinations and the court's evaluation of the evidence. We submit that is not a basis to overturn the trial court's thorough and thoughtful opinion. Let me first address the appellant's challenges to the process. What you heard today is the exact same narrative that the appellants told at trial. Court carefully considered all of these supposed flaws in the process, but the court also considered the many strengths of the process. And that's what the court was supposed to do, apply a disciplined balancing test. After reviewing the full record, the court found that on balance, the process strengths far outweighed any individual flaws in the process, and the court's opinion is replete with factual findings about the strength of the process. For example, the court found that the committee exerted their bargaining power against Mr. Lutnick and prevailed in obtaining consequential concessions, that the committee's advisors were qualified, independent, and not beholden to Cantor, that the special committee was well informed of the material facts when it voted to approve the transactions. Each of these factual findings is reviewed only for clear error, and as you heard today, appellants do not even attempt to meet that standard. Instead, they just ignore all of the court's factual findings and ask this court to reverse the trial court's thorough opinion based upon a few snippets of evidence that are still being taken out of context. It is the antithesis of affording deference to the trial court's determinations, and frankly, it would render the entire trial a meaningless exercise. But since appellants seem intent on retrying this case on appeal, I would like to briefly address some of the supposed process flaws that you heard about today, because in each instance, the answer is the same. The trial court carefully considered the evidence and just disagreed with the appellant's version of events. You heard, let's talk about the selection of advisors. They say, well, it was the controller, Mr. Lutnick, that selected the committee's advisors. Trial court found that wasn't true because the evidence showed that it was not true. Instead, each of the committee members testified credibly, the trial court found, that they selected their advisors because they had a good working experience with both Sandler and Debevoise in connection with the prior eSpeed transaction. For example, Dr. Bell's testimony at A494, Mr. Moran's testimony at A596. Then you heard today they testified that Mr. Lutnick had a veto right. Again, the court found otherwise. Why? Because Mr. Moran testified that he simply kept Mr. Lutnick informed about the process, but that Mr. Lutnick had no veto right. In his words, information, not approval. That's at Appendix 618. You also heard today the appellants trying to make much of certain flaws in the process. This court has made clear that a perfect process is neither possible nor expected as a condition precedent to a determination of entire fairness. It's a balancing test, and here there is no question that the court found that on balance, the process strengths far, far outweighed any flaws. And they talked about some of those early communications between Mr. Lutnick and Mr. Moran. As the court noted, those communications took place in February of 2017 before the process had even gotten underway. On March 14th, 2017, the BGC board passed the enabling resolutions that fully empowered the committee to negotiate that Berkeley Point transaction. That's at B112, and once that happened, the court found the committee did its job independently, and it did it effectively. That's what the evidence showed. And there was another point that was not lost on the court when it was evaluating the process, and that was the presence of the committee's legal advisor, William Regner, at Debevoise. They mentioned the fact that we didn't call Mr. Regner. That's because there was zero dispute that Mr. Regner was fully independent and fully effective as legal advisor, and Mr. Regner, the chair of the M&A group at Debevoise, was involved at the earliest stages of the process. For example, B110, he's the person who set up the banker interviews. He was there at the very beginning, advising the committee on their fiduciary duties and overseeing the entire process.
Could you address and tell us how we should be thinking about, if at all, Mr. Gossen's withholding, forgive me if I mispronounce the name, Mr. Narasimhan's
Sure.
communications regarding his opinions regarding value?
Sure. A couple of responses, Your Honor. I think the most pointed answer is the court statement at opinion page 69, quote, "I have no evidence that would allow me to understand how Narasimhan reached his conclusions." It was a one-page email. It's at appendix 1349. Why did the court say that? That email was produced in the very early stages of discovery, well over a year before trial, and yet the plaintiffs never attempted to depose Mr. Narasimhan, never attempted to bring him to trial. The court had no basis to
I'm not suggesting it should be used to set value, but wouldn't that have been information that would have been useful to the special committee?
Your Honor, again, the short answer is no. The court, Mr. Gossen, looked at it and found that the email on its face, the valuation it provided, was simply implausible. The lower end of Shekhar's valuation for Berkeley Point was $462 million. That was roughly $50 million below just Berkeley Point's book value, which was over $508 million. And remember, that's not even accounting for the fact that in 2016, Berkeley Point did $125 million in net income. It did more than that in 2017. So Mr. Gossen looked at it, found it was simply not credible, and the court happened to agree with that. The other point I would make on that, Your Honor, is it's interesting now that the appellants are faulting Mr. Gossen for not turning over that email to the committee, because throughout the trial below, the appellants argued vigorously that it would have been farcical, that was their word, farcical, for Mr. Gossin to be involved in any type of valuation because he reported to Mr. Lutnick, and according to the appellants, he was, quote, hopelessly conflicted. That's at Appendix B85. Your Honor, there were also some questions today. There was a question to appellant's counsel about the timing, and what he responded was, well, timing is important here because Cantor withheld critical information about those CCRE buyouts, putting aside the fact that the court found that the information about the CCRE buyouts was not material, and that was because the buyout numbers were based not upon any type of market evaluation, but instead upon numbers specified in the limited partner agreements that the investors had. Putting that aside, it is undisputed. The committee got all of the information about the CCRE buyouts. In fact, if you look at Sandler's May 31st presentation, it's at B293, B296, it has slides specifically referencing the information about that CCRE buyout. They had it. May 31st was over a week before that June 6th negotiating meeting. The other point I would make is that, as the court notes at page 67 of its opinion, the plaintiffs admitted, and Brian Sterling of Sandler testified, that Sandler got all of the information that it needed in order to evaluate the transaction. Your Honor, let me spend a few minutes now on price, because appellants make the same arguments based on the same evidence that they made at trial. All this evidence was tested, poked, and prodded by the trial court, and we even had supplemental briefings, specifically on valuation issues. The court weighed all the evidence, adopted parts of the experts' methodologies, modified others, calculated a range of values by doing its own analysis. That's what it was supposed to do. As this court stated in Conn v. Lynch, when faced with differing methodologies or opinions, the court is entitled to draw its own conclusions from the evidence. Here, the court calculated one end of the range by applying the market multiples of Walker Dunlop, and there is no question whatsoever that Walker Dunlop was the right comparator to use when valuing Berkeley Point. Appellant's own expert admitted Walker Dunlop was the closest publicly traded company to Berkeley Point. That's at Appendix A879. And every other witness agreed, and that included Ira Strasberg, who had been both the CFO at Berkeley Point and the CFO at Walker Dunlop. That's at Appendix 729. At the low end of the range, the court used the guideline transaction method that appellant's own expert espoused during the trial. The only difference is that the trial court adjusted the 2014 multiples to reflect the dramatic increase in Berkeley Point's performance between 2014, when Cantor bought it, and 2017, when it sold it to BGC. Now, Mr. Barallo said, well, Berkeley Point and Walker Dunlop were not identical. We agree. Berkeley Point was growing much, much faster. Between 2014 and year-end 2016, Walker Dunlop's net income grew by 49%. Berkeley Point's net income grew by 83%. That's at B361.
But why wasn't there an adjustment?
Why wasn't there an adjustment to the Berkeley Point multiples?
Yeah.
There was a slight adjustment upward. In fact, we would have argued the adjustment to Berkeley Point's price to book value should have been much higher. If you look at the time period between 2014 and 2017, Walker Dunlop's price to book multiple increased by 70%. Here, for that team, all the trial court did was apply a 35% increase to Berkeley Point's multiple.
How do you respond? Mr. Varallo said a number of times that the Walker Dunlop analysis was illustrative, and that they cite in their brief an excerpt from the report that says their conclusions were based on a number of other different valuation methods that rely on a larger number of firms. So if we say in Sonorama that we accord a high level of deference to the court's financial valuation analysis, what do we make of reliance on an expert when the expert is saying, I'm relying on other things? Does that matter? How do you respond to that?
So Dr. Hubbard did a number of different analyses, including a comparable company analysis, pegging Berkeley Point to Walker Dunlop. But even beyond that, putting aside the expert testimony, If you look at Sandler's fairness opinion, and they took 5 weeks between the time the deal was agreed and the time it was approved by the committee to prepare that fairness opinion, and if you go through it, really the primary way in which Sandler justified this price as fair, and in fact at the low end of the range of values, was by pegging Berkeley Point's value to the multiples that were used by Walker Dunlop. There was never any dispute that Walker Dunlop should have been the company to which Berkeley Point was compared. The only dispute was, should those multiples be adjusted down, as appellants argued, or should they be adjusted up, as we argued? That was the only dispute during the trial. Now, there was also some talk about an early $700 million number that was thrown out by Mr. Lutnick. That was in February of 2017. As the trial court found, everybody testified. Nobody viewed it as an offer or any type of firm price or any type of analysis behind it. But putting that aside, what's important here is the evidence showed that the committee still used that number that was thrown out in early February for negotiating leverage against Cantor. In its presentation for that June 6th meeting, that advocacy presentation, Sandler referenced that low $700 million number in arguing for a lower price. That's at B315. And while Sandler acknowledged that the market multiples had increased since Cantor threw that number out, Sandler argued that BGC should not have to pay up for the increase in the multiples because the delay was due to Cantor and Cantor alone. Lastly, I just want to briefly address this notion that somehow this case sounds the death knell for the entire fairness standard. That makes no sense. The entire fairness standard exists to protect minority shareholders, and it does that by ensuring that interested controller transactions like this one are put under a microscope and reviewed with rigorous scrutiny by the trial courts, and that's exactly what happened here. The trial court put this case under a proverbial microscope, reviewed a pile of documents, heard testimony from all of the key players, and it was only after undertaking that rigorous review that the court determined that the Berkeley Point transaction was entirely fair to the BGC shareholders. We would submit that this case is proof positive that the entire fairness standard is alive and well, and it's doing its job. Thank you, Your Honors.
Thank you very much.
Good morning, and may it please the court. I'd like to address the independent directors. So the special committee here was formed to independently evaluate, negotiate, and then accept or reject this transaction. And that's just what it did, with 4 independent directors who are distinguished and experienced at the top of their fields, who really brought their experience to bear in evaluating this transaction.
So what do we do with Mr. Varela's argument about the director who essentially derives 60%, I think, of his income from his directorship?
Well, the question there, as the Court of Chancery recognized, is whether that influenced his actions at all in this transaction. Of course, the analysis under Kerwood has 2 parts. 1, whether the person could be independent of Lutnick, and then 2, whether the person actually advocated for Lutnick in the transaction. And the court, after actually hearing Mr. Kerwood on the stand and taking the measure of him, found both that he could be independent for purposes of Cornerstone, and also that he did not do anything to advocate and that he advocated for the BGC shareholders and not Lutnick during the transaction. And the focus, I think, from plaintiffs is on the amount of money that he received. But, this court has already said it can't be the case that only super wealthy people can be on the boards of directors. The fact that someone derives significant income from being on a board of director doesn't make it so that they're necessarily compromised. The question is, could they act independently? And here, Mr. Kerwood is a Pulitzer Prize-winning investigative journalist. His whole career is based on pushing back on people, questioning people in power. He actually won a Pulitzer Prize for that, related to some investigations about school desegregation. And the court heard from him and said his strength of character is obvious, and actually that he had significant opportunities to make the money that he needed for his family from other places, from his speeches, from his public radio salary, from his ability to serve on other boards. And when went through all of that and said, even receiving this money, Mr. Kerwood credibly testified, and I'm quoting from the court's opinion on page 58, that he was committed to walking away from the deal if he felt the finances were not appropriate for BGC and its minority stockholders. He emphasized that the loss of his board seat was never a consideration during negotiations, and the court said, I have no basis to doubt that Kerwood was independent and acted independently throughout the negotiations. I mean, this is someone who was not going to risk his reputation for Mr. Lutnick, basically, that he was someone who, would push back and did push back. So on both parts of the cornerstone analysis, both the independence from Lutnick, the court said his strength of character is obvious. And then with respect to what actually happened during the transaction, the court said there's no evidence here that there was anything he was doing to advocate for Mr. Lutnick. He went to the meetings just like everyone else, evaluated the evidence just like everything else. There were no particular interactions with Mr. Lutnick or anything that would suggest that he wasn't independent. And so I talked a little bit about, I mentioned Dr. Bell. I don't know that plaintiffs really challenged Dr. Bell at this point. She's an economist and provost of a major university. She was there the whole time pushing back and pushing hard on price and on the structure for this transaction. We just talked a little bit about Mr. Kerwood, who's the Pulitzer Prize-winning journalist. We also should talk about Bill Moran, the person with the 30-year career at JP Morgan Chase, where he was general auditor and executive vice president. And then there was the fourth person, Secretary John Dalton, who was not only Secretary of the Navy, but president of Ginnie Mae. And the point of this is that, these are serious people who went through a rigorous process. I think Bell is basically unchallenged at this point. And then they had world-class advisors. Dalton, of course, is unchallenged. The plaintiffs have never challenged Secretary Dalton's independence. And then they had world-class advisors, Sandler and Debevoise, who were there the entire time. Debevoise, also unchallenged. They didn't call Debevoise at trial. They didn't make any arguments about Debevoise. And I just think it's telling that you've got, people who are admittedly both the directors and the advisors unchallenged. If there was something wrong with this process, you think they would have said something.
Did Mr. Lutnick recommend these advisors?
With respect to their original board seats, for some and not others, Mr. Moran, for example, was put on a Cantor-affiliated board in 1999, not recommended by Mr. Lutnick, but recommended by someone else.
The advisors, the committee advisors.
Oh, I'm sorry, I misunderstood the question. So the committee chose the advisors. The court found that was absolutely undisputed, that the committee, once it was fully empowered, made the decision to choose the advisors. Mr. Lutnick did not choose the advisors,
I
but he got
understand you're drawing a distinction between choose and recommend, but he did recommend these advisors, right?
Well, I think the committee, he obtained some information about the advisors, and let me talk about each individually because I think it matters. Let's talk about the financial advisor, Sandler. Now, Sandler and Mr. Sterling at Sandler had worked on special committees before for Cantor-affiliated entities, pushing back on Mr. Lutnick, and that was why Sandler was one of the two financial services firms that was considered by the committee. And the only interaction that Mr. Lutnick had there was to participate on a phone call that Debevoise ran at the beginning of the process, where Debevoise had, Moran was on the call, Debevoise was on the call, and the reason that Mr. Lutnick was there was to provide information about the process so that the companies could provide a proposal to act as financial advisor during the process. Like, he just gave information about what was going to happen during the process. And then after that, it was up to the committee to choose its advisors. This was in March, once it was fully empowered, and the committee chose Sandler.
Didn't Sandler have conflicts?
No. So the court considered all of the arguments that plaintiffs made below about conflicts. One of the suggestions that was made, for example, was that Sandler wanted to have a role in an IPO that was going to happen, but Mr. Sterling from Sandler testified that the IPO was essentially fully baked at that point. There were no major roles that were available, and the court said that there was no conflict or lack of independence because of Sandler's eventual minor role in the IPO, and that's on pages 63 and 64 of the court's opinion. Actually, plaintiffs made the argument below that the role was so minor that it was irrelevant. So that was not any kind of conflict. And then with respect to what Sandler did through the rest of the transaction, the court found that it was undisputed that once the committee was fully empowered, that Sandler was working on behalf of the committee and pushing hard to get the structure that would be best for BGC shareholders and to get the price that would be best for BGC shareholders. And there were so many meetings that this committee had where Sandler was preparing financial advice and analyses and going through them with the committee. There were 19 meetings over the scope of, I think it was 4 or 5 months. There were Sandler and made over 175 information requests to the Cantor entities to find out more that might information that might be relevant to the proposed transaction. Sandler took the time it needed to provide the financial analyses and to go through them with the members of the committee. Offers and counteroffers were exchanged. And then there was this June 6th negotiation where Sandler and the members of the committee bargained hard against Mr. Lutnick. And with the court's permission, I'd just like to talk about that a little bit because I think the plaintiffs suggest that we don't know what happened during that negotiation, and that's just not a fair reading of the record if you look at the court's opinion. So what the court said was there was a presentation that Sandler and the special committee had prepared that they were going to use to negotiate to open this presentation on June 6th. And so Mr. Sterling went through this presentation and explained why the price that had been suggested by Mr. Lutnick was not an appropriate price and pushed back and suggested a much lower price, something at the $720 million range, if it was for 95% control, and went through all the reasons for that. And it turns out that the Cantor side and Mr. Lutnick weren't happy with that. And there was some back and forth, and they actually walked out at one point. And then it was up to the members of the special committee, 2 of whom went and talked to Mr. Lutnick individually and said, look, we're not going to do this deal unless we can buy 100% of the company. We are not going to do a deal for 95% control. And there's a lot of testimony in the record that Mr. Lutnick wasn't happy about that, but recognized that that was the only way that the deal was going to get done. And so the minutes of the meeting showed that when the negotiations came back together, there was a counteroffer that was made by Lutnick. We don't know what that amount is. That's the only mystery that there is, what that counteroffer was. But we know the eventual number that they settled on, which was lower than the offer that was made by Mr. Lutnick and Cantor, and one that was really borne out by the fairness opinion that Sandler put together after 5 additional weeks of diligence. And so, here I think the plaintiffs really focus on a couple of interactions early in the process, and here the court looked at those and was critical. The court didn't just find everything for one side or everything for another side. It was a very fair and balanced analysis, but the court said, even with some of those things that Mr. Moran did early in the process, they did not affect the overall process. Mr. Moran, in particular, worked tirelessly on behalf of the special committee. He advocated for the deal structure that furthered BGC's minority stockholders over Cantor. He was prepared to say no to Lutnick and walk away if the deal was not to the special committee's liking. And so, at the end of the day, I think, we really end here where this all began, which was a trial, a lengthy trial, where the court heard from all 3 of these individuals and almost everyone else involved in the transaction.
Thank you very much.
Should be affirmed. Thank you.
Please, the court, 4 short rebuttal points. First, Sandler, clearly erroneous finding. Page 10 of the opinion, the court found Sandler was not given an IPO role. In fact, they were. A453 of the appendix.
You're out of time. Thank you very much,
Thank
Mr.
you, Your Honor.
Ruth. We appreciate the